We, the jury, return the following verdict.
All rise. Department 16 is now in session. I'll look the one presiding. Please be seated. Thank you. I'm lining them up, Your Honor.
And let's go ahead and set forth our appearances for the record.
Your Honor, Will Kemp, Pepperman, Theodore Parker, Plaintiffs, and we have a new expert in the audience, Mr. Rich, who's our economics expert. Our county expert.
Good afternoon, Your Honor. Joel Odou at the Kaufman on behalf of the Little Water parties.
Good afternoon, Your Honor. Scott Rasmussen, Ryan Flanagan, and Brittany Lyons on behalf of Hanna Instruments.
Good afternoon, Your Honor. Rob Robbins from Milwaukee Instruments.
Okay, once again, good afternoon to everyone. Ready, sir?
Yes, Your Honor. All rise for the jury. Please be seated.
All right, do the parties stipulate to the presence of the jury?
Yes, Your Honor.
Yes, sir. And so, ladies and gentlemen of the jury, did you select the four persons?
Yes, sir.
All right, and so, ma'am, it's my understanding the verdict has been reached, is that correct?
Yes, sir.
And could you hand the verdict form to the marshal? All right, let the record reflect that I'm going to hand the special verdict form to the court clerk to read into the record, ma'am.
District Court, Clark County, Nevada. Orion Gallagher et al. Versus AffinityLifestyles.com et al. Case number A21-834-485B, Department 16, Special Verdict Form. We, the jury, return the following verdict. Real Water has admitted liability for plaintiff's damages. The court has determined that Hanna is liable for plaintiff's damages. Regarding question 2, did Milwaukee fail to provide an adequate warning that would have been acted upon? Yes. Regarding question 3, was this a substantial factor in causing the injury to each of the following plaintiffs? Orion Gallagher? Yes. Keith Haley? Yes. Jerome Botes? Yes. Richard Belsky? Yes. Yvonne Arnone? Yes. James Hu? Yes. Kathleen Ryerson? Yes. Regarding question 4, did Milwaukee breach the implied warranty of fitness for a particular purpose, i.e. was the MW500 ORP meter unfit for measuring negative ORP when making alkaline water? Yes. Regarding question 5, was this breach a substantial factor in causing the injury to each of the following plaintiffs? Orion Gallagher, yes. Keith Haley, yes. Jerome Botez, yes. Richard Belsky, yes. Yvonne Arnone, yes. James Hu, yes. Kathleen Ryerson, yes. Regarding question 6, in the amount of damages for plaintiff Orion Gallagher for past and future physical and mental pain, suffering, anguish, and disability and permanent injury, if any, $6 million. Regarding question 7, the amount of damages for plaintiff Camille Gallagher for past and future mental pain, suffering, and anguish, $500,000. Regarding question 8, the amount of damages for plaintiff Brian Gallagher for past and future mental pain, suffering, and anguish, $500,000. Regarding question 9, the amount of damages for plaintiff Keith Haley for past and future physical and mental pain, suffering, anguish, and disability and permanent injury, if any, $2 million. Regarding question 10, the amount of damages for plaintiff Jerome Botez for past and future physical and mental pain, suffering, anguish, and disability and permanent injury, $2 million. Regarding question 11, the amount of damages for plaintiff Richard Belsky for past and future physical and mental pain, suffering, anguish, and disability and permanent injury, $2 million. Regarding question 12, the amount of damages for plaintiff Yvonne Arnone for past and future physical and mental pain, suffering, anguish, and disability and permanent injury, $3 million. Regarding question 13, the amount of damages for plaintiff James Koo for past and future physical and mental pain, suffering, anguish, and disability and permanent injury, $5 million. Regarding question 14, the amount of damages for the pain, suffering, and disfigurement of Kathy Ryerson, $6 million. Regarding question 15, the amount of damages for plaintiff Patricia Sutherland as an heir of Kathleen Ryerson for past and future grief and sorrow and loss of support, companionship, society, and comfort, $500,000. Regarding question 16, the amount of damages for plaintiff Judith Ryerson as an heir of Kathleen Ryerson for past and future grief and sorrow and loss of support, companionship, society, and comfort, $500,000. Regarding question 17, the amount of damages for plaintiff Richard Ryerson as an heir of Kathleen Ryerson for past and future grief and sorrow and loss of support, companionship, society, and comfort, $500,000. Regarding question 18, is Real Water liable for punitive damages? Yes. Regarding question 19, is Milwaukee liable for punitive damages? No. Regarding question 20, is Hanna liable for punitive damages? No. Dated this 4th day of October, 2023, Jessica Yates, foreperson, juror number 7.
All right. And do any of the parties desire to have the jury poll?
Milwaukee does, yes.
All right.
Ladies and gentlemen, is this your verdict as read?
Yes. Yes.
Ms. Is this your verdict as read?
Yes.
Mr. Is this your verdict as read? Ms. Is this your verdict as read? Mr. Is this your verdict as read?
Yes, it is.
Ms. Is this your verdict as read? Mr. Is this your verdict as read?
Yes.
Ms. Is this your verdict as read? Ms. Is this your verdict as read?
Yes.
Miss, oh, sorry.
Thank you, Your Honor.
You're welcome, sir. And counsel, can you approach very quickly? All right. Okay, ladies and gentlemen, first and foremost, I just want to thank all of you for your efforts. As far as the individuals that have been serving on the jury, and understand we have alternates and we have the general jury pool, and I've discussed with you that. Based upon your decision currently, there's one more phase, right? And I want to explain this to you because you made a determination as to the award of punitive damages, correct? And I just want to explain to you how that process works because it's my understanding, and I talked this over with counsel, they're going to have a very, very brief discussion with you as to what they anticipate the amount of punitive damages should be. And they tell me that they anticipate it shouldn't take more than a half an hour. Is that right, Mr. Parker, Mr. Kemp, and Mr. Odou?
Yes, sir.
Right. And so after that's done, you go back and you deliberate again for how much time you feel you need, whether it's an hour, late into the evening, or if you want to come back tomorrow and do that. But I'm kind of speculating a little bit, but I would think you'd want to finish up tonight. Is that correct?
Yes.
Yeah, all right. I guess I was correct in that part. And as far as the alternates are concerned, and you don't think we need alternates for this phase, do you, counsel?
No, Your Honor.
No, Your Honor.
Right. And so you're free to leave. However, and I went in and talked to you about it, and you have to understand this. This is random as far as ultimately where you end up as alternates, and I think I told you that. But understand during the course of this trial, we almost lost 2 jurors, right? We had one that had some issues, and we had another, and so on and so on. But without underlining that, when you have a 6-week jury trial, you have to have others willing to participate, because it has happened from time to time where we've had cases go to trial and 1 or 2 panel members get sick, and then what? You have to start from scratch. And we don't want to have to do a do-over. And so I want to make sure each of you that served as an alternate in this case understand that your participation was just as important as those that ultimately made the decision. You understand that? Really and truly. And the lawyers, thank you, and the clients, thank you for participating in this process. Because I did remember at the very outset, I came down to talk to you when you're filling out the questionnaires, and remember we talked about the preamble to the Constitution of the United States. We talked about justice, and you look at that, and you know that's the first concern the founders had when this great nation was established, and that's justice. And we also talked about the fact that they wanted justice even before they founded this country. And so what I'm going to do is this: we're going to try to, I don't want to say expedite, but we want to make sure we're efficient with time. We just do. And so what we're going to do is we're going to take, I have one discussion I have to have with counsel, and it shouldn't take very long. And then after that's done, we're going to bring you back in and we'll have argument. Is that correct, counsel?
Yes, Your
Yes, Your Honor.
Yeah. And then you go back and deliberate, and you have to determine what the punitive damage amount is. Okay. And Mr. Marcus.
All rights to the board. Your Honor, we have
Oh, yes, we do. We always say, thank you for.
Please be seated.
No, you don't have to.
Roger.
We have to be efficient. Ladies and gentlemen, remember this, and you know this, but you're admonished not to converse amongst yourselves with anyone else on any subject connected with the trial, or read, watch, or listen to a report or a commentary on the trial, any persons connected with this case. Remember, and you know this, no social media until you're done. And last but not least, do not form or express any opinion on any subject connected with the trial until the cause is finally submitted to you. And Mr. Marsh, you know what to do, you take the jury back and you can release the alternates.
Yes, Your Honor.
Now, alternates, if you want to stay and come back and listen, you can do that too. I don't think council has any objection to that.
No objection. I'll meet you guys right outside. Okay? Meet you guys right outside.
Please be seated and thank you. You're welcome.
Any objections?
I think he should have a chance to get to while we're still in a water fight up here. That's not fair.
I understand.
No problem. I'm gonna go make a phone call though, because
Sir, you need to go.
I will not talk to the alternates. I have been in such, I've heard the objection.
Yeah.
Okay, Mr. Odou, so what do you need?
Thank you, Your Honor. So we understand the role of the jury. We have to have a punitive damages instruction. I'm sure it won't take more than a minute to finalize that, as well as the punitive damages verdict form. The punitive damages instruction has been circulated between plaintiffs and Real Water. The issue that I wish to address to the court is taking into account the subject defendant's financial condition.
Take that out.
I mean, that's the question. So here is the issue, Your Honor. Obviously, the court's well aware that Real Water is in bankruptcy proceedings. And for the record, obviously, we've made a prior objection that punitive damages may or may not violate a bankruptcy order. I don't intend to re-argue that. The court has acknowledged that's an issue for a different court. I just want to make a record that we acknowledge that that was an issue addressed and incorporate those arguments by reference. The second issue is it seems that throughout the course of the trial, the plaintiffs have intended to argue that the jury should send a message to the water industry. We think that will result in an excess verdict. We think that to compare Real Water to Nestle, to Dasani, to Coca-Cola, Pepsi, whoever, is inviting error and is inviting an excess punitive damages award. The evidence that we're prepared to offer to the jury, well, first of all, we understand the plaintiffs don't intend to offer any evidence. They just want to go to argument. And there's a problem with that. I'll let plaintiffs respond to that, I guess, before I continue. But we do believe there's a way to provide evidence for the jury to consider. It could even be a stipulated fact as a way to proceed. But we want to make sure that this verdict is reasonable and pursuant to Nevada law. And so that's the concern that we wanted to address outside the presence.
Yeah, Judge, on the bankruptcy point, as counsel knows, we made offers of judgment that one of the plaintiffs is beat Real Water's insurance company decided not to pay them. So who cares if they're in bankruptcy? The insurance company's going to be on the hook for it, number one. Number two, on financial condition, there's two reasons for punitive damages. One is to punish the defendant depending on their financial condition. And two is to send a message. When you're punishing the defendant has the right to raise the annihilation defense, that the damages are too big, they'll annihilate me. Real Water can't do that because they annihilate themselves. They filed for bankruptcy. So that's not a defense in this case. Punishment is an issue in this case, vis-a-vis the punitive damages for Real Water. The only issue is exemplary. Making an example of them so no one else does this again. And, maybe Mr. doesn't like it, but most of the big water bottlers are big companies, like Dasani, that we mentioned, and like Coca-Cola. And, if you're going to send a message, jury has the right to send any kind of message they want to. And if he thinks that the punitive damages are excessive, he has a remedy. He can file a motion for judgment on leave. I'm sure he will. But until we're at that point, he can't argue now for some sort of artificial cap on punitive damages, especially when it's really the insurance company's problem.
I have one comment, and this is, really important on this specific issue for everyone to consider, because this is not my first experience with the punitive damage. I've had a number of cases. But here's my point, and Mr. Kemp can probably refresh my recollection a little bit more than what I remember, but I remember in the endoscopy cases, it was my recollection there was a punitive damage award of approximately $500 million. And at the end of the day, it was reduced, and it was reduced post-trial. And there were issues raised regarding annihilation, but this is important too. Whatever the punitive damages are, they have to be in some proportion to the compensatory damage claim. And at the time, I think I relied upon the State Farm case out of Utah, which is a federal case that went up to the Nevada Supreme Court. And they put an outer limit, you know,
That's right, John.
procedural process.
We talked about this during the limine hearings. You know, we contend you should follow Judge Posner because it's a public health case. They contend it's a 10-to-1 limit, but you know, this is not the day to argue that.
And I don't know if it's, I don't know what it is now, but this is all I'm saying, and this is bottom line in it. I'm saying, look, at first, we don't know what the jury punitive damage award can be in this case. We have no clue. But just as important too, is if it's excessive, potentially, and that's the argument, as a trial judge, I'm gonna do what's right. And Mr. Kemp, once again, I'm just going on memory, it's been 10 years or so, give or take, but it's my recollection, there was a significant reduction.
That's correct, you know, we got chopped.
Yes, you know, it was, I don't remember what the figure was, but it was significant. It was hundreds of millions of dollars, you know. And so all I can say is this, and I don't mind being clear on this, and this is what I try to do, and say you gave the example of Mr. Parker. Sometimes when in a heat of battle, you don't realize what the trial judge is doing, but then you step back and say, you know what, yeah, maybe he was right, you know. And that's kind of what I'm really focusing on, because, for example, if you have, because I don't even know how we can even ferret these issues out in front of the jury right now, because they're going to listen to argument. And regarding it, it shouldn't take very long, and I want to make sure we follow our promise as far as they're concerned. But my point is this, if there's a significant, you have an annihilation issue, I get it, right? Just as important too, I understand where the plaintiffs are coming from a deterrence and so on and so on. I get that too. But the bottom line is going to be this. Post-trial, whatever the law is, I will follow.
And Your Honor, you've done that throughout the course of this trial, and we don't need to.
Yeah, I understand.
Otherwise, you're calling balls and strikes, we get that.
Yeah.
The issue, so there's two issues I'd like to address. First of all, the insurance issue does not concern Real Water. We don't represent the insurance companies, and the offers of judgment issue is an issue for other lawyers and other courts. And so to say that that somehow justifies an argument made in this court doesn't hold water. And so we object if that's the argument to use, to present that the jury should send a message to Dasani or to Aquafina or to Fiji or to any other water company, because that is not tied to the facts of this case. The facts of this case, and that's the second point I wish to make, is at best, Brent Jones testified that the best year that Real Water had was they had $9 million in sales. $9 million in sales is a fact that could be put before this jury. We have an excerpt from Brent Jones' deposition queued up to play before this jury. It could even be a stipulated fact. We don't even need to play that before the jury. We could go right to argument.
Judge, that fact shouldn't be played for the jury because that goes to annihilation. That's the only reason to play that, just for annihilation offense. Like I already said, you cannot argue that Liberty Mutual, the 71st largest company in America with net assets of $154 billion, he can't argue that whatever this jury gives is going to annihilate them. Real Water cannot be annihilated because they've already taken that path themselves. So he can't tell the jury, oh, it's a $9 million company and try to get the award down. That's an annihilation defense. The only issue we have is exemplary. What is an adequate amount to make an example of it? That's the only issue.
I wasn't finished with And that's exactly the point, Your Honor. To argue that the jury should award punitive damages based on the financial condition of Liberty Mutual is not proper.
I didn't say we were gonna argue based on.
You can't do that.
I said there's no annihilation possibility here.
Didn't finish. But that is the realm of damages that they are apparently seeking. That realm of damages, when you compare it to a company that pre-COVID, its best year, or years plural, was making around $9 million, invites error from the jury, and it invites intervention from this court post-verdict. And so we believe to put that argument before the jury is improper to begin with. Yes, this court has a remedy, but why invite the jury to commit error that this court then has to correct? And we just want to make sure that the record is clear that we've objected to that. As far as putting
And
the,
what do I do? And this is the real difficulty as far as this case is concerned, because it is in a unique posture procedurally with
Yes,
the
it is.
bankruptcy, you know? And so, can you, and this is something maybe the Supreme Court has to grapple with, but under that set of facts, what do you do? You know, because for example, I mean, in good faith, can an annihilation defense be raised? What's the impact?
They didn't even plead it as an affirmative defense. It's gone right there. And number one, and then the facts. You know, they can't tell this jury that any punitive damage award, even if it's $1, will annihilate them because they've already gone to the bankruptcy court. There's no possible annihilation defense here.
again, I didn't finish, but I appreciate Mr. Kemp's argument.
I thought the judge asked me a question.
No, I was asking, no, I was just pointing out.
It's all good, we're all friends.
Yeah, no, I was just pointing out the bankruptcy twist to this whole
Yes.
thing. That's what I was doing, you know, and here, at the end of the day, and this is an important one, and I can't remember what the exact figure was, but in the endoscopy case, I know I reduced the punitive damage award by 250 to 300 million, something like
If
that.
you took it from 500 to 220 something, 280 something.
Yeah, something like that. They weren't
It was a
happy
big
with it.
shot.
It was a big shot, right?
And I didn't
But-
argue about it. I didn't argue about it.
No, I understand. I mean, and believe it or not, what I did was, I think I had a very detailed decision. Remember, I was following the State Farm case out of Utah.
BMW.
Yes,
think
I
we
had
talked
an
about
analysis
justice.
done and things like that.
Well, and that's exactly the point, Your Honor. Whether or not we mentioned BMW in our answer, it's still the Constitution of the United States due process, and they are inviting a jury verdict in violation of BMW by arguing we're the size of Dasani, Fiji, Aquafina, or any other very, very large water company. That in and of itself is improper. They're asking the jury for a verdict that they know that this court can't enforce, and that's improper. I just wanted to make sure the record is clear on that. If the court would like, I can certainly object if and when those arguments come up. I'm trying to make this process go quicker, and then further as to the,
And you can have a standing objection to that.
I will take that.
Yeah, here's the next thing though, and I was thinking about that. And ultimately, these are, I mean, we don't know what the jury's gonna do.
We do not.
You know, but for the record, I don't mind saying this, when it comes to that specific type of issue, I think, from a judicial perspective, that would invite very unique briefing, post-trial as to what to do with the punitive damage award, if any. Because we're assuming there will be one, but we know this. Two of the defendants didn't have a punitive damage claim asserted against them. I mean, a finding against them, I should say. So we don't know what they're going to do. I'm looking at it from this perspective, and at the end of the day, and this happens from time to time, sometimes you have runaway verdicts, where the verdicts aren't really tied to what the claims are. Sometimes juries' verdicts are inadequate, right? And that's where post-trial issues come up. And here's my point, and I kind of get sending the message, and how far that goes, I can't tell you. But one of the fascinating, and this is my final comment, that what happened was, and this is what I understand, and lawyers can correct me if I'm wrong or not, but the endoscopy case did send a message in the medical community And it did have an impact on injection practices.
An immediate impact, John.
Right, you know, notwithstanding the fact it was reduced. Just the fact that it was, you know, and I have no clue and I don't care as to ultimately what happened with that. But that's kind of my point, that's with the deterrence. It's not necessarily whether or not it's collectible or any of those things. And so what I'm gonna do, I'm gonna let the lawyers, I'm gonna let you do what you think it would be in the best interest of your client. This is a unique issue, and all I can tell you is at the end of the day, just like I did in the prior endoscopy case where there was a significant verdict, I did what the law required me to do.
So just so we're clear, Your Honor, would the court prefer that we object, or is the court going to give us a standing objection?
Standing objection.
Thank you, Your Honor.
And the reason why I want to do that is this, to be really candid with you, and you don't have any problem with that, do you, Mr.
No,
Kennedy?
Your Honor, I think the thought that the jury does the constitutional limit is flawed in the first place.
Yeah, but my point is I wanted to go a little smoother for both sides.
Yeah, it's getting late, we want to
Yeah.
get a final result tonight.
Exactly, and then I know there'll be significant post-trial motions. All right.
I
So,
think that's, as far as
the forms.
the form we have to get, and we have to resolve the objection, so I have proffered the testimony of Brent Jones, the plaintiffs have objected. I think we need a court ruling on that, and then I think we're ready to proceed.
Yeah, Judge, that $9 million, that first of all, it implies they're facing, and second of all, it raises the specter of an annihilation defense, which they didn't raise an affirmative defense. Even if they had, they're in bankruptcy. So annihilation is not an issue, and that is the only relevance of the $9 million.
So then, just so we're clear, then we object to the jury instruction, with that being removed.
Wait, let me see the jury.
I said we can take that out.
No, I know, if we take it out, I object to taking it out, and I object to not allowing the testimony. I'm just asking the court to make a decision, that's all.
First you asked me to take it out, now you don't want me to take it out.
I do not want it out, to be clear. We've had some back and forth, and maybe I wasn't clear. I do not want it removed, but if it is removed, we object. We've proffered the testimony of Blaine Jones, plaintiffs have objected. The court will rule, and then we'll either play it or not.
Judge, on the jury instruction, I'd rather stick with the standard instruction, even though I don't think it's appropriate in this case. I'd rather just stick with it, so we don't have an issue on appeal.
Well, I agree with that, right? And so, I just want to make sure.
So we have the instruction, and we believe the testimony should be played. Plaintiffs have objected. We just need is it a ball or strike?
Okay. Here, and I got one last comment on that. What do I mean, I can just tell you this, normally we've taken that type of testimony, but I've never had an issue when there's a bankruptcy.
And that's why we've offered it, Your Honor, because we believe it resolves a lot of issues that we've raised about the fairness of a punitive damage award. It gives the jury some type of measuring stick rather than inviting the jury to commit error by comparing real water to Dasani or comparing real water to any multi-million or multi-billion dollar company. Clearly, real water was not a multi-billion dollar company. And once you say send a message to a billion-dollar company, we think that's a problem.
And my last question, is it an affirmative defense or not? That's what I'm looking at, it has to be asserted.
I believe we have a catch-all affirmative defense. I believe we have a constitutional affirmative defense, but I have to share an answer. No one comes to look at it.
For the record, I was just taking a quick look as to whether or not it has to be asserted as a affirmative defense or whether there's a way to have it known. Anything else? Because I don't know that answer.
Yeah, nothing else to add. I guess we just need to roll into the court to play the excerpt of Brent Jones or not.
If there was no affirmative defense, how can we, that's the jury.
Thank you for reminding me. That was the other issue I wanted to raise. On the annihilation, Your Honor, we've been planning a case law on this, but it is an argument we want to make because we think it goes against public policy. So when you have punitive damages awarded in a case, the object of punitive damages, the court is well aware, is to punish and deter the person that committed the wrongful act. In this case, we have a bankrupt entity. There is no punishment. There is no deterrence. It's no different than a deceased person. The case law was all over the place, all over the country on that, but we want to make sure that we raise that issue because perhaps somebody may want to take an appeal on that and make new law. But we don't believe punitive damages against a dead entity is allowed, just like it's not allowed against a deceased person.
Well, we have to make, this is what I'm going to do. I mean, it seems to me, and it really comes down to this one issue. If it's in the jury instruction, I'm going to let you do it as far as that. I mean, or that's what I'm going to do. And just as important too, I'll let you do what you have to do. No one is, I'm not briefed on whether it's an affirmative defense or not. I don't know if it is.
But now the only evidence we want to put before the jury, it'll go really quick and we can make argument.
Yeah. And we can still argue deterrence.
Understand, Your Honor.
They surely can't argue that, oh, we only make $9 million a year, this will annihilate us. They better not say that to the jury, because that's not in the affirmative defense. They haven't raised that. That would be completely improper.
Right. And we don't want to do that, just talk about the business. So.
We will talk about the business as it is still in business.
They're trying to raise an annihilation defense. That's why this $9 million shouldn't be in. They're just trying to backdoor an annihilation defense. Tell the jury, oh, you can't award more than, say, $10 million because it will annihilate us. That's what they're trying to do. It's a complete fraud. You know, there's no possibility that they can be annihilated when they've already filed for bankruptcy. So that's why the $9 million shouldn't come in. Number one, they didn't file an affirmative defense. And number two, even if they did, there's no possibility for annihilation.
Well, here's my question, then it's in we can't put it in the jury instruction if that's the case. Then
I think
they
it
can
should come out, I'm fine
Rock and a
with
hard
that.
place.
Right, pardon?
It's a rock and a hard place. We believe it should be in the jury instruction. We offer the testimony. It's up for the court and plaintiffs to decide if they want to object, then the court's got to make a ruling.
I do.
The jury instruction says you should consider evidence of financial strength. There is no evidence of financial strength. This is what they made before they filed for bankruptcy.
That's true. All right, we step out for one moment.
Yeah,
That issue to resolve. Thank you. I'm not going to just not.
Can we approach
what I used to do.
Yes.
All rise. Barbara 16 in alphabetical order. Seated.
All right, we're back on the record. Do we have the instruction prepared, Mr. Pepperman?
Yes, Your Honor, I gave a copy to Ms. Moser.
And for the record, Mr. Odou, have you reviewed the instruction subject to any objections you've made on the record?
Yes, Your Honor, the instructions are consistent with our prior discussions and prior objections.
Okay, no objection. Okay, and
We agree that we're just going to go straight to argument.
we're straight to argument. And last but not least, I will say this, we have a very patient jury. And so we can bring them in.
Yes, Your Honor.
All rise for the jury. Seated.
All right, the appointment stipulates to the presence of the jury.
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
Mr. Robbins, yes?
Yes.
Okay. Anyway, ladies and gentlemen of the jury, we've gone to the final phase of the case. And as a result, remember, I read jury instructions that were, I think it was a total of how many? Was it 53?
Yes, sir.
53. Right now, I am required to read you another set of jury instructions. However, this time there's only one. I just want to let you know that. And so this would be what we would call the exemplary or punitive damage phase, because you have to decide what that amount will be, and of course, that's up to you. And then I have one instruction, and this is called, we'll call this jury instruction number 1, that will be given to you to assist you, just like before, in your deliberations as it pertains to one issue, that's punitive damages. And so this would be the next jury instruction in line. It's identified as jury instruction number 1, but I guess for all practical purposes, it would be number 54, related to punitive damages. And the instruction provides as follows, quote, there are no standards, fixed standards for determining the amount of punitive damages reward. The amount is left to your sound discretion to be exercised without passion or prejudice and in accordance with the following governing principles. The amount of punitive damages is not to compensate the plaintiff for harm suffered, but is reasonably necessary to punish and deter the defendants and others from engaging in the conduct such as warranting punitive damages in this case. In arriving at any award of punitive damages, you are to consider the following. 1, the reprehensibility of the conduct of the subject defendant. And 2, the amount of punitive damages that will serve the purpose of punishment and deterrence, period. And that's the one instruction. And so at this time, I anticipate argument by Mr. Kemp, Mr. Parker, and then Mr. Odou.
Thank you, Your Honor. Ladies and gentlemen, good evening. I'll be brief. I don't think I'll be more than 8 or 9 minutes. First, I'd like to thank you for your compensatory decisions. It's going to be life-changing, and you might have a chance to talk to some of them afterwards, but it really is going to be life-changing, and we sincerely thank you. This is the exemplary damages phase, and I think, as some of you have probably already figured out, Mr. Parker and I are doing this for a couple reasons. One, we want the clients compensated, The two, we are interested in social change. And what do I mean by that? I want to give you a story, true story. On March 21st, 1980, the largest hotel in the world, the MGM Grand, burned down to the ground. 87 people were killed. Thousands of people were injured. And why did that hotel burn down to the ground? The reason it burned down to the ground is they had no fire sprinklers. And why did they have no fire sprinklers? They were trying to save money. Big corporation, they were trying to save money. So lawsuits were filed. And I was lucky enough to be one of the lawyers that represented the people who were hurt in the MGM case. I was young then. Our committee, the chairman of the committee, was a man named Neil Gallitz, who just happened to be a mentor of the judges, taught me, taught the judge. This man was a great trial lawyer. So in any event, as a result of the MGM case, all the hotels in Las Vegas got sprinklers. All the buildings, the office buildings, the government buildings in Las Vegas got sprinklers. It spread nationwide. Nationwide, almost every hotel has sprinklers in it. Almost all the office buildings have sprinklers in them. And that was because of the MGM fire case. 87 people had to die, but because of that case, we got social change. So, social change in this case. What change, in my view, is required? The change I think is required is you need to make an example, to send a message to every food and beverage maker in the United States that if you're going to come up with a brand new product, whether it's water or otherwise, at least test the product. That's the message that needs to be sent. The second message, if people are complaining about your product, investigate it. That's the other message that needs to be sent. And, you know, the message in the MGM case was heard. Look up there. That's a sprinkler. Look up there. That's a sprinkler. There are 18 sprinklers in this room. 18. That's because of Mr. Gallitz and his work on the MGM case. That was the social change. And we'll never know how many people did not get killed in subsequent hotel fires or injured in subsequent hotel fires or office fires. We'll never know. But we do know, just look above you. Walk through the courthouse. I mean, there's probably 200 sprinklers on this floor alone. But a big change was made, and Mr. Parker and I think that that's what the punitive damages phase is about. Thank you very much.
Thank you, sir.
Good evening, ladies and gentlemen.
Good evening.
Let's get the number out the way. When I met with you on September 6th actually, I leaned into a number I've never actually presented to a jury. I said $2 billion, remember that? And that was a hard number to lean into. And I say that because I've done punitive damages before, both on the plaintiff side, like I am today, as well as defending on the defense side. And the first time I did it involved a death. And I may tell you that story in rebuttal. The second time I did it, it dealt with a client of mine who was one of my first clients back in the early 90s. And it was against an insurance company in that case. It was a direct action against an insurance company who failed to pay on a claim. And he owned a construction company. And the insurance company sent out a claims representative and said, listen, we're going to investigate this claim because your construction was doing work. A vagrant set the work on fire. And he came in and made the repairs, over $500,000 worth of repairs. And the insurance company said, we'll come out and take a look at it, and then we'll reimburse you. Months and months and months went by, turned into years, they never reimbursed him. Small company. So I ended up having to sue the company. And we go through trial, and the company raised every reason why they shouldn't pay. And this client was going through cancer, very tough time. And spending $500,000 that the insurance company indicated they would pay took a big bite out of this company. So I said, listen, we'll do it. And that night before we went to trial, the jury agreed. The insurance company should have paid. And they struck the box saying we want to consider punitive damages, just like you are. And that night before, I had to lean into the mirror several times about how much I was going to ask this jury for. Because I knew how much it meant to his company. And this other company, I knew that was a drop in the bucket to them. But I also knew that if we didn't stand up and send a message, other companies would treat other companies the same. So it took me, and this is something we do, I leaned into it. They say that in the military, or they say that you lean into it. You don't shy away. And it took me a while to lean into what I was going to ask that jury. And I asked that jury for a big number, several $1 million. And the jury gave it. But I had to first lean into it myself. Now I want you, this group, and I'm going to talk to you a little bit more in rebuttal, so this is going to be short right now. My rebuttal is going to be short too, I'll tell you. But I want you to lean into this decision. You leaned into the first decision, and it took you a while. And we appreciate all the time you've taken. And I've seen how you've taken copious notes. Obviously, you guys have put in a lot of time. I want you, and I'm going to give you, in my rebuttal, more reasons why I believe you should. But I want you to award $1 billion in punitives. I believe you need to send a message. This company is one of many companies in the bottled water business. You've seen us drinking water in yourselves all day long. You have to send a message that says, because we are a society of bottled water drinkers now, that we shouldn't have to worry about you testing the water that we're drinking. We shouldn't have to worry that it's hydrazine in it or any other toxin. And the only way to make sure is to test, like Mr. Kemp said. The only way to ensure that the water we're drinking is safe is to at least investigate complaints. No one should have to worry that that bottled water that they're drinking or they're giving to their kid, they're putting into their formula, is tainted or contaminated. So you're going to have to lean into it. I'm going to ask you, and I'm going to say this during the rebuttal, some additional reasons why. But I want you not to be shy. I don't want you to be afraid of it. I want you to be impactful. And it takes a lot. And I said that earlier. When I met you, I said, this case presents an opportunity for you to be impactful. And I want you to be.
Mr. Odou, sir.
Thank you, Your Honor. Ladies and gentlemen of the jury, good evening. I want to thank you on behalf of Real Water for your hard work in reaching a reasonable verdict. It took you a long time. We appreciate the effort and the time that you spent in entering that verdict. As to the punitive damages, well, let me start with where I began. There should have been one drop of hydrazine in the water. We've said that all throughout this case. Real Water injured those plaintiffs. We said that throughout this case. We understand your verdict. We understand the compensatory damages that you've awarded. If our number, if we did the math right, it's about $28.5 million. As far as the punitive damages verdict, we're not going to suggest a number to you. We believe that you've exercised a lot of good judgment and that you'll continue to exercise calm and reasonable judgment, which is what the verdict provides. I just want to cover a few very quick items. I know you've probably heard this before, but I'm going to say it again. Real water caused these injuries. You've heard that Real Water recalled the water in March of 2021. You've heard that the FDA found hydrazine in the water in October of 2021. Okay. Those facts are not in dispute. Again, the plaintiffs keep saying that the water was not tested. The water was tested. There's no doubt about that. We've got page after page after page that we could have showed and did show some of the weekly, monthly, yearly, every 4 years testing. This is a failure of imagination, a failure to understand that there was hydrazine in the water. John Marlowe didn't know there was hydrazine in the water. Brent Jones didn't know there was hydrazine in the water. And Blaine Jones, who made the concentrate that made these plaintiffs sick, that made him so very sick, didn't know there was hydrazine in the water. Blaine drank the water. You heard what Blaine went through. You heard what these plaintiffs went through. It's terrible. There's no doubt about that. We ask that you return again, a common, reasonable verdict for punitive damages. And again, in all seriousness, on behalf of the attorneys and to some extent the court, thank you very much for taking the time to hear our arguments and to render a verdict. Thank you so much.
Thank you, sir. And Mr. Kemp.
Nothing more, Your Honor.
Thank you. Mr. Parker.
Yes, sir.
Ladies and gentlemen, this will be my last time talking to you in this setting. Perhaps we'll get a chance to talk outside. Mr. Odou, I've known him for a long time, and he's indicated to you that testing was done. He seemed to fail to address the fact that not a single investigation was performed, despite that whole laundry list of people who got sick. Not one. So if you were to accept his position on the testing, how do you ignore the failure to investigate? He's giving you no excuse for it. He's tried earlier, when I say he, his client made a decision a week before we met to concede liability. One of the messages you're sending is that ordinary people, perhaps those who can't afford to have an attorney, those who don't have attorneys that are willing to take 53 depositions, go through the disclosure of expert reports, everything it took to get this case to you. Without that, there is no message. Without that, you don't get the opportunity to be impactful. When Mr. Odou indicated testing was done, perhaps they tested for things that you typically test when you don't have a new way of making water. And that's the problem. If you're going to be creative or come up with some unique way of doing things, test to determine whether or not that unique or creative way actually compromises the safety and health of those you're trying to create as customers. Real Water representative said that the goal at Real Water was getting product out the door and making money. If that's what their goal is, how else can you be impactful but to address money? Money should never come before the safety of consumers. It shouldn't come before you determining what you're trying to make money off of is actually appropriate to be in the marketplace. When you stop caring about your customers and you only care about money, there is no other way of being impactful but to what? actually use money to deter that conduct. There's no other way. That's what's important to them. And since they've showed you who they are, your employees have told you how important it was for them to make money, because when qualified employees are fired or are told to give away free water instead of investigating people's sicknesses, their health, their hospital stays, this is what happens. You have families losing a loved one. You have liver biopsies. You have 6 people with acute liver failure looking down the barrel of biannual tests for the rest of their lives. The only way to prevent this from happening, because you know, tomorrow there'll be another real water. Tomorrow there'll be some other fancy water. Someone has tried something new. You have to make sure today that that company comes up with their new real water, tests, investigates. Otherwise, we know what happens. And we know what it takes to make people accountable. It takes a week before trial starts before they at least accept some responsibility. Again, I ask, you lean into this decision. Don't shy away from it. And hold them responsible. Thank you very much.
Okay, thank you, Mr. Park.
Thank you, Your Honor.
Mr. Marshall. Okay, ladies and gentlemen, we're going to continue the final phase of the deliberation process. Sir, we're in your custody control. Pardon? You're going to deliberate.
Yes.
Not to see anyone else. Well, I guess the admonishment's still good. They shouldn't go and get on the online. So.
We have a question, sir.
Yes.
Oh, interesting. I never had this before. Understand, we don't have a witness on the stand. And we did have one question from one panel member, and my response would be, sir, read the jury instruction. Remember we talked about that at the very beginning, right? Even down when we were doing the initial swearing in. All right, sir.
All right, so report to the jury.
Last, I'm going to read it just to make sure.
Yes.
You're advised not to converse amongst yourselves with anyone else that may be subject to this trial, to read, watch, and listen to the report or commentary on the trial. And by any other means of information, including without limitations, newspaper, television, radio, remember the social media prohibition. And last but not least, that do not form or express any opinion until this matter is submitted to you for deliberation. That's what you're going to do.
All right, so report to the jury.
You can be seated and thank you. All right, and counsel,
I got that one.
That's 2, right? At least.
No, he kind of saw my George.
Oh, I went off the record, is that okay?
Yeah, that's it. You go to
Probably 16 in alphabetical order. Please be seated.
Okay, thank you, man. And let's go ahead and set those appearances.
Your Honor, Will Kemp, Pepperman, and Teddy Parker.
We'll do Mr. Kaufman for the water entities.
Scott Rasmussen, I again, and written lines on behalf of Hanna Instruments.
Rob Robbins from Milwaukee Instruments.
All right.
All rise for the jury. Please be seated. Thank you.
All right, do the parties stipulate to the presence of the jury?
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
Okay. And ladies and gentlemen of the jury, have you reached a verdict on the punitive damages?
Yes, sir.
All right, can you hand it to the marshal?
District Court, Clark County, Nevada. Orion Gallagher et al. Versus AffinityLifestyles.com et al. Case number A 21-83-44-85B, Department 16, punitive damages verdict. We of the jury return the following verdict. Punitive damages are awarded against Real Water in the following amount. $200 million. Dated this 4th day of October, 2023, foreperson.
All right. And do the parties desire to have the jury polled?
No, Your Honor.
No, Your Honor.
Okay, ladies and gentlemen, we're done. And I just have, and it's a little late in the evening, so I don't want to spend much time, but I just want to thank all of you for coming down here and your service. I mean, we've been together now, I guess, how many weeks?
A lot.
6 weeks, actually more than that when you factor in your commitment to come down. And we started the process with the jury questionnaire. And I remember spending some time with all the potential family members and explaining to them why they were selected and how important jury service is. And I made that pretty clear. And it's patently apparent to me that each and every one of you, and I just think this is important, I overlooked when the alternates took their duties very seriously. And so I just want to thank you for coming down, not just on behalf of myself, but the lawyers involved in this litigation. Of course, their clients appreciate you coming down in service. And I want to thank you on behalf of my staff. And it's been a pleasure. And so you're going to be released at this point. And as you leave, it's kind of up to you as to what you want to do. But the lawyers sometimes will have questions. You can respond to those if you want to. If you don't want to, that's up to you. But trust me on this one fact. They will never challenge your decision making. What counsel many times would do is this: they might ask you this specific questions about evidence because they look at it as a clinical opportunity for them because they try a lot of cases. And so they never want to challenge the verdict. They might ask you, well, what do you think about this testimony? Or, well, this was important. Why? And all they're trying to do is learn from you. Understand that? Isn't that correct, counsel?
Yes, sir.
Yeah, that's it, you know. But anyway, you are officially discharged. All right. And we'll be in recess.
All rise to the portion of jury. Counsel, I'll have them outside, waiting in the hallway outside.
Thank you all.